everyone, my name is Disha Mehta, legal intern at LEXIS and Company and a law student at Gujarat University. And today we are going to talk about another topic which is known as Doctrine of Restitution. So first let us start by the meaning of the term restitution. So the word restitution comes from a Latin word restituere, which means to rebuild or to restore. The word restitution means the restoration of benefit and putting the plaintiff in the original position that would stand before the contract and restraining the defendant from making a wrongful gain. In simple terms, relinquishment of a benefit or the return of money or the property obtained through an improper means to the person from whom the property was taken. So this is the general meaning of the word restitution. Now let us start the definition of Doctrine of Restitution. So Section 5 of the Indian Contract Act 1872 defines the rules of Doctrine of Restitution. It deals with the obligation of a person who has received advantage under void agreement or contract that becomes void. So according to Section 65 of the Indian Contract Act 1872, when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he has received the same. So this is the definition of the Doctrine of Restitution. Now let us see that what are the essential elements which are necessary for the constitution of a Doctrine of Restitution. So the essential of the same are: first, this should be a contract between the parties. The next one is there should be a lawful consideration for the same contract. Third is the parties should be competent enough to enter into an agreement. And the fourth is there should be a failure to perform the part of the contract due to uncertain events. So these are the essential of Doctrine of Restitution. Now let us see what are the exceptions of the same. So the exceptions to the principle of Doctrine of Restitution are: first, the principle of Doctrine of Restitution is not applicable if there is no agreement or contract between the parties. Second is, the principle of Doctrine of Restitution is not applicable if the agreements are void ab initio. The third one among the same is, the principle of Doctrine of Restitution is not applicable if the agreements are entered into with incompetent persons. For example, agreement entered with a minor or an unsound person. So these are the exceptions to the Doctrine of Restitution. Now let us see what was the important case in which this doctrine was applied. So it was Mohri Bibi versus Dharmodas Ghosh, which was happened in 1903. So here the facts of the case were: Dharmodas Ghosh was the owner of an immovable property. He mortgaged his property to Brahmodat in order to secure 20,000 rupees. There was also 12% interest on the amount. During the time of mortgage, Dharmodas was a minor. The question before the court was the validity of minor entering into an agreement, and there was also issue regarding the validity of the contract if an individual misrepresents the age. So this judgment of the case was: the court held that Dharmodas Ghosh was not bound to pay back the amount and gave the verdict in favor of Dharmodas Ghosh. The court also set guidelines regarding the validity of contract between a minor and a major. The court held that any contract with a minor is void ab initio. So this was the important case, and by this we can conclude that Doctrine of Restitution helps in restoring the possession or the benefits of the affected party. It ensures the fact that there is no unfair advantage to other person. As long as the essential principles of Doctrine of Restitution are met, a person can claim restitution. So this was the Doctrine of Restitution. If you have any doubt in this doctrine or any other related topics regarding the previous videos, then you can please write down in the comment box below. Thank you.